Gordon Bird here. Obviously, big news breaking as we are recording this. We just heard from U.S. Labor Secretary Alexander Acosta, who was speaking about his role in the prosecution of financier Jeffrey Epstein a decade ago in Miami, in South Florida, regarding charges involving basically alleging statutory rape of underage victims that led to him pleading guilty to a charge and doing some jail time, which has been pointed out by many people as basically a sweetheart deal that was way out of line as far as what someone should get for that kind of a sentence for those kinds of allegations. And we have an expert to discuss those charges and Secretary Acosta's response to the questions that have been raised about the way he handled that case a decade ago, now that Jeffrey Epstein is facing new charges from the federal district in New York City. We have Western Michigan University Cooley Law School Tampa Bay campus professor, a former Miami-Dade judge, Jeffrey Swartz, on the line with us. Professor Swartz, good afternoon.
Good afternoon to you.
Now, as we speak, it's just about an hour or so after Secretary Acosta finished making some remarks, basically defending his role in that case as the U.S. attorney for that region of Florida back about a decade ago. And I guess one of the questions I want to start with is his efforts to point out that this had been a state case and that his office's intervention was what kept Epstein from avoiding jail entirely in that case. He ended up serving, I believe, about a year behind bars and had to register as a sex offender. So I guess the question there is, as he put it, whether getting that jail time and getting Epstein to register as a sex offender was a better deal than a roll of the dice on what a full prosecution would have involved. Judge, your comment.
Well, as I can say that this particular deal and this particular prosecution was the subject of a great deal of conversation in Miami-Dade, especially among prosecutors and defense attorneys and some judges when it took place. The real problem here is, number one, I think that's a kind of an insult to the state prosecutors who were actually after Mr. Epstein. I'm not sure that I accept Mr. Acosta's version that he somehow saved that prosecution. And even if he claims that he did, he certainly did not do everything he should have done, and he clearly violated the law himself in regards to not making disclosures to the victims in the case as he was required to do under federal law. Mr. Acosta is brilliant in the context of his background. However, the one thing that we all knew when he became U.S. Attorney is that despite working for the Department of Justice Civil Rights Division, he was wholly and completely unprepared to be a prosecutor. He had never been a prosecutor in his career, and I'm not sure that he really understood what his role was as a prosecutor in Miami with the U.S. Attorney's Office.
Now, the reason that he gave, and it's, if you can help us in the lay community out here kind of understand this explanation, he said that he didn't inform the victims, if I'm understanding this correctly, because he didn't want to jeopardize their opportunity to go after Jeffrey Epstein in civil court for restitution, that had they known about the deal, it might have been used against them because they would have known that there would have been the opportunity to sue and get money. What is your take on that, Judge?
That's really kind of nonsensical. First of all, he had a requirement to inform them, and he chose not to. I don't know how that would have affected their ability to seek any type of civil damages against Mr. Epstein. It seems almost the reverse, that by not telling them that the matter was over, by not informing them that the deal basically foreclosed criminal charges involving their complaints, somehow prevented the civil cases from being filed. I don't understand it. It's nonsensical. It makes no sense whatsoever. part of what bothers many people, and it bothers me, is that there is an expression in the Department of Justice and U.S. Attorney's Office that goes, the eagle never flies. That means that the eagle that is on the front of the Department of Justice emblem that's at every U.S. Attorney's Office never goes anywhere. You want to talk to the U.S. Attorney, you go to the U.S. Attorney where he is. He does not come to you. And Mr. Acosta has never explained, at least as far as I know, what he was doing 90 miles away from his office in Palm Beach, sitting in a hotel room, talking to Alan Dershowitz and other defense attorneys and working out a deal that basically took a case away from the state authorities and foreclosed his office from further investigation. I just don't understand.
As someone who is part of the legal and judicial community at that time and around that time, I'm sure you have your share of opinions of not only Mr. Acosta, but those around the case who, particularly attorneys who were, I guess you could say in a way, Jeffrey Epstein's enablers in that case and perhaps have been up to this moment.
I think those attorneys did what they were supposed to do. They were representing their client, and they were doing the best they could to get the best deal they could for their client and to represent him the best they could, and I don't have a problem with that. What bothers me is that for whatever the reasons are, before Mr. Acosta went to the grand jury and even got an indictment, he was persuaded by Mr. Dershowitz and the other people that were representing Mr. Epstein by some, I think, a 59-page memorandum not to file charges and somehow convince him, based upon their investigation of the victims, that he just had bad victims and they were going to beat the case and he should take whatever they were willing to give him. It should also be noted that none of Mr. Acosta's assistants were with him at that meeting. He went to that meeting by himself. That is kind of unheard of for a U.S. attorney. To not take the assistants that are actually performing the investigation, FBI agents that were actually involved in the investigation, and have them have some input and know what's going on. Somehow or another, there was this closed-door meeting, and I still, to this very moment, do not understand how that occurs. As a defense attorney, I had to walk to the U.S. Attorney's Office to represent my clients, and there was always FBI agents, there was always assistant U.S. attorneys there. There were always a crowd of people, and everybody was taking notes. I have not seen the first note taken at this meeting.
The argument that seemed to be advanced during the Acosta news conference that, I guess in so many words, that was then and this is now, and that in the climate of 2008 versus 2019, perhaps today, judges would not have been as likely to allow victim shaming on the part of the defense, and perhaps now versus then, that juries would have been more receptive and believing of the victims. What are your thoughts on that as somebody who was, again, in the legal and judicial community at that time?
Well, first of all, we have a rape shield law in the state of Florida. So their reputations and character assassinations can't take place. The issue is what occurred between them and Mr. Epstein. And the idea that somehow in 2008 these victims would have been less credible than they are now makes absolutely no sense to me. This is a situation where you had numerous people, and Mr. Acosta was aware that there were numerous people making the same allegations that basically corroborated each other as to the type of conduct he was engaged in and how he became engaged in it with these victims. Makes no sense to me that somehow this was a bad case. I just don't understand how he reached that conclusion without having the participation of those who were actually involved in the investigation, or for that matter, even having the local prosecutors at this meeting with the defense attorneys with him. Why weren't both jurisdictions represented? And why was he doing things that were foreclosing any further investigation?